Listen carefully. While the country is locked into the daily noise of polling numbers, courtroom drama, and non-stop election theater, something far more consequential just happened quietly inside the Supreme Court. No rallies, no protests, no breaking news banners, just a procedural move that could fundamentally change the cost of holding the most powerful office in America. This is not about political embarrassment. It is not about reputation, headlines, or approval ratings. What is now on the table is something far more concrete and far more dangerous. We are talking about personal financial exposure, the kind that doesn't fade when the news cycle moves on, the kind that follows you for life. Asset seizures, judgments that drain estates, wealth accumulated over decades evaporating to satisfy civil verdicts tied to decisions made while serving the country. In finance, there is a basic rule that separates amateurs from professionals. The most lethal risks are rarely the loud ones. The real dangers are buried in the footnotes, hidden inside technical language that most people never bother to read. That is exactly where we are right now. The Supreme Court has quietly agreed to review a case that places the presidency itself under a financial stress test, not symbolically, not theoretically, but in terms that investors would recognize immediately as solvency risk. This is not just about Donald Trump. He happens to be the vehicle, not the destination. The court is using this moment to ask a much larger question that has been avoided for decades. Does holding the office of president now carry personal financial liability for actions taken under the authority of that office? And if so, how much risk is acceptable before the job itself becomes structurally unsustainable? What should concern you is not the noise surrounding this case, but the silence. When the Supreme Court prepares to reshape abortion law, gun rights, or voting rules, the country knows. Media mobilizes, politicians posture, activists flood the streets. None of that happened here. This docket advanced with the quiet efficiency of an institutional audit. No commentary, no urgency, just a cold procedural acknowledgement that something foundational needs to be examined. From an investor's perspective, this silence is a warning signal. Markets understand that uncertainty is more dangerous than bad news, and what the court has done is inject uncertainty directly into the balance sheet of executive power. For nearly half a century, American governance has operated on an assumed framework that presidents and senior officials were insulated from personal financial ruin for official acts. That insulation functioned like limited liability in corporate law. The institution bore the risk, not the individual. That assumption is now being tested, audited, possibly dismantled. Imagine a Fortune 500 CEO who knows that any major decision he signs could later trigger a personal lawsuit that reaches into his private bank accounts, his home, and his children's inheritance. That CEO doesn't become more responsible. He becomes paralyzed. He stops making bold decisions. He avoids risk not because it's bad for the company, but because it's bad for him personally. Now apply that same dynamic to the Commander-in-Chief of the United States. That is the bankruptcy being discussed here. Not just financial bankruptcy, but a bankruptcy of action. A system where leadership hesitates, not out of principle, but out of fear of personal ruin. If this framework shifts the wrong way, the presidency doesn't become more accountable. It becomes functionally weaker, slower, and more risk-averse at precisely the moments when decisive action matters most. The Supreme Court's decision to hear this case is not a political statement. It is an acknowledgement that the existing rules no longer provide clarity, and when clarity disappears at the top of the system, instability follows everywhere below. The question now is whether the office of the presidency remains a position of authority protected by institutional safeguards, or whether it quietly becomes the most financially dangerous job in America. That answer will not be decided by voters, pundits, or cable news debates. It will be decided in the fine print of immunity doctrine, civil liability, and constitutional procedure. And by the time the consequences become obvious, it will already be too late to undo them. To understand how we arrived at this moment, we have to rewind and examine the transaction that brought this case onto the Supreme Court's docket. In business, you never evaluate risk in isolation. You trace it back to its origin. You ask where the liability was created, how it was transferred, and why it was allowed to compound without being resolved. The same discipline applies here. This case did not emerge from some abstract constitutional debate. It began as a civil lawsuit filed quietly in federal district court. Not a criminal prosecution, not an impeachment proceeding, a civil action. And that distinction matters more than most people realize. Criminal cases threaten liberty. Civil cases threaten assets. They target money, property, and future earnings. They are designed not to punish, but to extract compensation. From a financial perspective, civil liability is often more dangerous because it has no clean endpoint. There is no sentence to serve, no pardon to grant. There is only payment. The plaintiffs were not asking a court to send anyone to prison. They were asking a jury to assign a dollar value to alleged harm and to collect that value directly from the individuals who held office. Their argument was built around a concept familiar in corporate governance. When executives act within the scope of their authority, the corporation bears the risk. But when executives exceed that authority, when they act ultra vires, the corporate shield can be pierced. In this case, the claim was simple and radical at the same time. The officials acted beyond their lawful powers, and therefore the protection of the office should not apply. The defendants responded exactly as you would expect any rational actor to respond. They moved to dismiss the case on immunity grounds. Their position was that the actions in question were taken as part of official duties and were therefore insulated from personal liability. This was not a technical defense. It was a structural one. It rested on the long-standing assumption that government cannot function if its leaders are constantly exposed to personal lawsuits for policy decisions. Then something unusual happened. The district court rejected that immunity defense. It did not end the case. It allowed it to proceed, and in doing so, it triggered the most dangerous phase of civil litigation for any institution: discovery, the forced opening of records, communications, internal deliberations. In the corporate world, this is the moment when risk stops being theoretical and becomes existential. Even if a company ultimately wins, discovery alone can be devastating. The defendants attempted to stop the bleeding. They sought an interlocutory appeal, essentially asking a higher court to pause the process and restore the protective barrier before irreparable damage was done. This is standard practice when immunity is at stake, because immunity is not just a defense against liability, it is a defense against the process itself. Here is the point where the risk profile changed dramatically, and where most media coverage completely lost the plot. The appellate court did not deliver a clean answer. Instead, it issued a fractured ruling. Some actions were deemed immune, others were not. The line between protected official conduct and potentially personal liability was left ambiguous. In financial terms, this is the worst possible outcome. Not loss, not victory. Uncertainty. And this is the moment that should make you stop and pay attention. Because once a system operates under unclear liability rules, behavior changes immediately. Executives begin to second guess. Lawyers begin to over-lawyer. Decision-making slows, not because the law demands caution, but because the risk cannot be priced. At this point, the case could not remain where it was. Lower courts had effectively created a fragmented liability regime for the presidency. In one jurisdiction, an action might be safe. In another, it might be catastrophic. That kind of inconsistency is intolerable in any system that claims to operate under the rule of law. The Supreme Court stepped in not because of politics and not because of personalities, but because the legal marketplace demands certainty. When the court agreed to hear the case, it was not agreeing to resolve a dispute between specific parties. It was agreeing to audit the architecture of executive accountability itself. The question was no longer whether someone acted properly in this instance. The question became whether the existing framework for protecting executive officials still functions at all. This is the quiet escalation most people missed. The case moved from a disagreement about facts to a confrontation over doctrine, from a lawsuit into a stress test. And once a matter reaches that stage, outcomes stop being narrow. They become precedents. They become rules that govern behavior long after the original names attached to the case are forgotten. By the time the case reached the Supreme Court, it was no longer about what happened in a particular moment. It was about whether the office of the presidency still carries an implied liability shield, or whether that shield has begun to crack in ways that no one fully understands yet. And that uncertainty is precisely why the next phase of this case matters far more than the one that brought it here. When the Supreme Court agrees to hear a case, it is not inviting a broad philosophical discussion. It is doing something far more precise. It is selecting a small set of questions that will determine the outcome, and more importantly, the rules that govern future behavior. In this case, the court narrowed its focus to 3 questions that together form the entire liability framework of the executive branch. If you understand these questions, you understand why this case matters. If you don't, you are watching the surface of a process that is reshaping the system underneath. The first question goes directly to the heart of executive power. It asks what kind of immunity, if any, a former president or senior executive official is entitled to when sued for actions taken while in office. This is not an abstract debate. Absolute immunity means that as long as an action falls within the outer perimeter of official duties, personal financial liability is off the table entirely. It doesn't matter whether the decision was wise, reckless, or even malicious. The shield holds. Qualified immunity, on the other hand, is a far weaker protection. It only applies if the official did not violate clearly established law that a reasonable person would have known. On paper, that distinction sounds reasonable. In practice, it is destabilizing. The standard of clearly established is not fixed. It evolves over time. What is permissible today can be condemned tomorrow by a new interpretation. If the court concludes that former presidents receive only qualified immunity, every decision made at the edge of legal authority becomes a potential personal liability waiting to be activated after the term ends. And this is where the stakes escalate. Because once personal liability enters the equation, the presidency stops being an institution insulated by design and starts looking like a sole proprietorship where every major decision puts private assets at risk. The office itself becomes a liability magnet. Now pause for a moment and think about what that actually means. Imagine a president facing a national emergency, weighing options that will inevitably harm some group, disrupt some industry, or provoke litigation. If the law tells that president, you may be personally sued years from now, depending on how courts reinterpret this decision. The incentive structure changes immediately. Leadership shifts from decisiveness to self-preservation. This is the moment where many listeners instinctively say, "Good. Accountability is necessary." And accountability is necessary. But the court is not deciding whether accountability matters. It is deciding how much financial risk the system can tolerate before decision-making itself begins to fail. That line is far thinner than most people realize. The second question the court agreed to resolve determines who is even allowed to challenge executive action in court. This is the issue of standing. In constitutional law, standing is the gatekeeper. It determines whether a plaintiff has suffered a concrete, particularized injury that entitles them to judicial review, or whether they are merely expressing a generalized grievance shared by the public at large. This distinction sounds technical, but it controls the volume of litigation that the executive branch will face going forward. If standing is relaxed, almost any major policy decision becomes contestable by anyone who can articulate some downstream harm. The courthouse doors swing open. Lawsuits multiply. Governance slows as injunctions and appeals stack on top of one another. Here is the hook that should make you lean forward. If standing is relaxed while immunity is weakened, the presidency does not just become more accountable. It becomes legally saturated. Every major decision turns into a potential years-long legal battle, not against the institution, but against the individual who signed the order. But the opposite extreme is just as dangerous. If standing is tightened too aggressively, entire categories of executive action become functionally immune from review. Policies that harm millions in small increments escape judicial scrutiny because no single person can show sufficient individualized damage. Rights exist on paper, but no one has the procedural access to enforce them. The court's third question determines where the money comes from if liability exists at all. This is the doctrine of sovereign immunity. The United States cannot be sued for damages unless it has explicitly consented to be sued. The plaintiffs in this case attempted to avoid that barrier by suing individuals instead of the government, arguing that unconstitutional actions are not actions of the state at all. The defense argues the opposite, that when officials act using government authority, resources, and power, any lawsuit against them is effectively a lawsuit against the United States. If the court accepts that logic, sovereign immunity closes the vault. There is no payment, no compensation, only prospective relief, if any. Taken together, these three questions form a single system. Immunity determines whether officials can be sued at all. Standing determines who can sue them. Sovereign immunity determines whether there is any money to recover. Change one element, and pressure shifts to the others. Adjust all three, and the structure of executive accountability is fundamentally altered. This is why the Supreme Court took this case, not to referee a political dispute, but to recalibrate a system that has drifted into contradiction. And once the court answers these questions, the presidency will not operate the same way it did before, regardless of who occupies the office. At this point, a reasonable question arises. If this case is as consequential as it sounds, why hasn't the market reacted? Why haven't stock prices moved, bond yields shifted, or headlines screamed crisis? The answer lies in a well-known weakness of modern markets. They are excellent at pricing short-term variables like earnings reports, inflation prints, and interest rate decisions. They are notoriously bad at pricing long-term constitutional risk. This case does not change next quarter's GDP. It does not immediately alter tax policy or regulatory costs, but it changes something deeper. It alters the behavioral incentives of the people who control the machinery of government. And when incentives shift at the top, the effects cascade outward slowly, unevenly, and often invisibly at first. Think about how deeply the executive branch is embedded in the daily operations of the American economy. Federal agencies issue permits, enforce rules, approve mergers, block acquisitions, levy fines, and interpret statutes in ways that can add or erase billions of dollars in value overnight. These decisions are not theoretical. They shape entire industries. And every one of those decisions is made by human beings operating within a legal framework that tells them how much personal risk they are assuming when they act. If the Supreme Court strengthens immunity and tightens standing, the risk shifts in one direction. You get what many executives quietly fear and many investors quietly depend on: the uncheckable regulator. An official who knows that lawsuits are unlikely to survive procedural barriers and that personal liability is effectively off the table has little external constraint beyond internal policy and political oversight. In that environment, enforcement becomes unpredictable. Decisions can feel arbitrary. From a business perspective, this is an unhedgeable risk. You cannot insure against a regulator who answers to no one. Now consider the opposite outcome. If immunity is weakened and standing is expanded, the risk shifts in the other direction. Officials begin to operate under the constant threat of personal litigation. Every enforcement action, every regulatory interpretation, every emergency decision becomes a potential future lawsuit. In that environment, the regulator does not become more fair. He becomes more cautious, more hesitant, more inclined to delay or avoid decisive action altogether. Here is the moment where the consequences become unavoidable. A frozen regulator is just as dangerous to markets as a rogue one. When enforcement is uneven because officials are afraid to act, the most aggressive actors gain an advantage. Rules still exist, but they are applied inconsistently. Compliance stops being a standard and starts being a gamble. And here is the hook that most people miss. This uncertainty does not just affect government. It feeds directly into boardrooms, legal departments, and investment committees. When companies cannot predict whether rules will be enforced boldly, timidly, or selectively, they pull back. Capital waits on the sidelines. Expansion slows. Innovation becomes more conservative. The economy does not collapse. It quietly underperforms. The ideal environment for business is not one with no regulation and not one with constant litigation. It is one with clarity, clear rules, clear enforcement boundaries, clear remedies when power is abused. That balance is what institutional investors refer to as the Goldilocks zone. Not too hot, not too cold, stable enough to plan around. The Supreme Court's role in this case is not to pick sides between plaintiffs and defendants. It is to stabilize the operating system, to tell both officials and citizens what the rules actually are. When the rules are clear, officials can act decisively without fear of personal ruin, and businesses can challenge genuine overreach without triggering chaos. If the court fails to provide that clarity, the uncertainty does not disappear. It migrates. It moves out of the courtroom and into the economy, into compliance budgets, into legal reserves, into decisions not to hire, not to expand, not to invest. That is the cost of doctrinal ambiguity, and it rarely shows up on a balance sheet until years later. This is why serious investors are watching this case, even if they are not trading on it today. They understand that governance risk compounds slowly. By the time it becomes obvious, the damage is already priced in. The question now is whether the court will reduce that uncertainty or institutionalize it, because whatever framework emerges from this case will shape how power is exercised, how it is challenged, and how much confidence the private sector can have in the predictability of the system. And predictability, more than ideology, is what keeps an economy functioning over the long term. At the end of this analysis, it becomes clear that this case is not really about a single lawsuit, a single president, or even a single moment in history. It is about how a republic manages power over time. Every system that endures eventually has to renegotiate its rules, not because those rules were wrong, but because the conditions surrounding them have changed. That is what the Supreme Court is doing now, whether the public realizes it or not. For decades, the American presidency operated under an implied contract. In exchange for decisive leadership, the office was insulated from personal financial destruction. That insulation was never written as a blank check, but it functioned as a stabilizer. It allowed presidents to act in moments of uncertainty without constantly calculating the personal cost of every decision. That framework produced both extraordinary achievements and undeniable abuses. And like all imperfect systems, it accumulated tension. This case represents the release of that tension, not explosively, but deliberately, quietly, through doctrine, through procedure, through questions that sound technical but carry enormous consequences. The court is not deciding whether power should be strong or restrained. It is deciding where the burden of risk should fall when power is exercised. On the institution or on the individual. If the court reinforces broad immunity and tight procedural barriers, the presidency emerges stronger, more insulated, and more dangerous. Action becomes easier, accountability becomes harder. The system relies heavily on elections and politics to correct excesses, trusting that voters will eventually respond. History shows that sometimes they do, sometimes they don't. If the court moves toward personal liability and expanded access to litigation, the balance shifts the other way. Power becomes cautious, slower, more defensive. The risk of abuse declines, but so does the capacity for bold action. Leadership begins to operate with one eye always on future lawsuits, future juries, future financial exposure. The presidency survives, but in a narrower, more constrained form. Most likely, the court will attempt something in between, a compromise that distinguishes categories of action, preserves some protections, and exposes others. That path may feel prudent, but it also introduces complexity, and complexity has a cost. When rules become harder to understand, fewer people understand them correctly. Ambiguity invites litigation. Litigation invites delay. Delay reshapes behavior long before any verdict is reached. What makes this moment unsettling is not that one side might win and the other might lose. It is that no outcome is free. Every choice carries trade-offs that will echo far beyond the parties named in the case. The presidency will not collapse. The republic will not end. But the character of executive power will change, subtly and permanently. And this is the part that history teaches us to watch closely. The most consequential shifts in governance rarely arrive with drama. They arrive through footnotes, jurisdictional clauses, and doctrinal adjustments that feel boring in real time. Years later, people look back and say that was the moment when everything began to feel different. This case is one of those moments. While attention is focused elsewhere, the Supreme Court is recalibrating the terms under which power is exercised and challenged. They are deciding how much risk society is willing to tolerate in exchange for decisive leadership, and how much restraint is worth the cost of hesitation. So the question is not whether you support the individuals involved, or whether you favor one political outcome over another. The real question is what kind of system you believe lasts longer. One that prioritizes insulation to preserve action, or one that accepts friction to preserve accountability. There is no perfect answer. There never has been. What matters is understanding that the answer is being written now, quietly, precisely. And once it is written, everyone will live under it, long after today's arguments are forgotten. That is why this case deserves attention, not because of who is on trial, but because of what is being renegotiated. In law, as in markets, the biggest risks are rarely the ones everyone is watching. They are the ones hidden in the structure itself, waiting patiently until the system reveals what it values most.